We last discussed the notice of lawful objection to government bodies or officials, whereby we advised them of our taking the oath of allegiance to the barons, and presented them with much evidence as to why Article 61 has been invoked and is still in effect. This notice is sent to those who have not yet made demands on us, but the one sent when demands have been made differs only slightly. Both are what is termed lawful instruments, meaning that they comply with various conditions which compel recognition by the legalistic fraternity and system. David Robinson's research, in which he was greatly aided by Elizabeth Becket, daughter of one of Britain's highest-ranking judges, revealed that the most effective way of promoting lawful dissent was to confront the legal eagles with their own weaponry. This accords well with the long-established tenet of the legendary Sun Tzu in his writings on the art of war, that when confronted with an enemy whose power seems overwhelming, the best strategy is to turn that power back on the opponent, using it against them. In law, the concept of behaving honourably is at least paid lip service by those who like to portray themselves as belonging to a superior caste of being. And these notices are designed to display these qualities. Hence some of the legalistic terminology and references to Latin, etc. Lawful instruments, for example, must be in writing, bearing the full identity of the protagonist, together with a physical address rather than a P.O. box. The signature must be a wet ink version, not electronic, and any statements must be made on penalty of perjury if later found to be misleading or false. Furthermore, they require acknowledgement and response by the recipient within a reasonable time frame, usually 10 to 14 days, but sometimes less depending on the urgency of the matter. Failure to observe any of these rules can place the participant in what is termed default. Persistent default, usually qualified as comprising 2 failures to respond, places a person in dishonour. This is a serious mistake because in law, to be in dishonour means that tacit agreement has been granted to the correctness of the opponent's position or arguments, since after 3 presentations, no attempt at rebuttal has occurred. In any subsequent court cases, the person in dishonour thus has virtually no chance of success. The second notice we send, therefore, informs the recipient that they are in default, but is affording them an opportunity to cure the situation. It is much shorter than the first because the evidence has already been presented, and this is merely a reiteration of the original statement and intent. We will have a quick look at this now, before moving on to discussion of some points which are very topical given that there is a federal election in a few days' time. At the top, we have the standard names and addresses, etc., together with the mailing date. This is followed by the statement of the purpose of the document and the information that it doesn't contain any obscure meanings, that the words used mean what they mean in normal, everyday English. Further, it defines what is meant by default and what is required to remedy the situation, which not only includes a lawful response, but rebuttal of the evidence in substance, meaning that simple gainsaying or opposing opinions are not sufficient. There follows the usual signing and witnessing before recording the posting, etc. One final point here When referring to the PP provision mentioned in the previous video, it would be prudent to obtain the permission of our witnesses to use their names in this way in writing, just to forestall any frivolous future attempts to cast doubts on the validity of our paperwork by desperate or nefarious legal practitioners. Here is an example of one way that this could be done. This is a sheet to which names can be added as the sphere of influence of Article 61 adherence expands. Or there could be one for each individual, but the former seems more efficient and convenient. A copy to be kept in each person's files. Now on to the topical news, that of the election in 2 days' time. We have touched on this before, and the position is clear. To engage in a sham election where people who are constitutionally disqualified from standing under the alleged imprimatur of a defunct constitutional act to take their places in an illegitimate parliament can only be described from a position of lawfulness as aiding and abetting treason. However, as most people are unaware of these facts, it is futile to expect them to abstain based on moral objection. Those who are aware of the true position, however, will have to salve their consciences as best they may. The argument is made by many that it's better to have some changes, however few, if they can be achieved, in the balance of power. But let's try to analyse the outcomes if this course is followed. Influential player, former Senator Rod Cullerton, has recently revealed that the Great Seal of the Commonwealth of Australia was removed from the Parliament and the Constitution illegally by Gough Whitlam almost 50 years ago, without any documentary or constitutional authorisation. He argues that this needs to be restored, and once that is done, we can move towards re-establishing a legitimate constitutional and parliamentary framework. However, he misses the point that since Article 61 was invoked, the entire fabric of Australia's constitution was rendered null and void. And what he is urging is merely the perpetration of one fraud over another, much like sewing a fresh patch over an existing patch over a rent in our clothing. It might look better, but it doesn't fix the underlying problem. Furthermore, evidence is becoming ever clearer that our two major parties, Labour and Liberal, are working hand in glove to further the destruction of Australia's sovereignty as a nation. Only a few days after this election, on May the 22nd, delegates from all over the globe, representing almost all nations, meet in Switzerland to potentially sign a treaty to place global health matters in the hands of the WHO and the UN, giving them power to impose whatever draconian measures they deem fit, without evidence, on those countries, and have them enforced by UN resources. Code for troops? It's become apparent that both Labour and Liberal are prepared to sign up to this. It is impossible to define surrendering sovereignty as anything other than treason under the British Constitution under which we live. As it says in our first notice of objection or conditional acceptance, quote, "This is a surrender of our sovereignty, a clear act of treason under the 1351 Treason Act, and a prémunire under the 1392 Act of Prémunire. It is treason under the 1559 Act of Supremacy and the 1689 Declaration and Bill of Rights. A prémunire is an attempt to establish papal jurisdiction in England. Both major parties have indicated that they are almost certain to sign up to this betrayal. So does it really matter if there are some independents in the House or the Senate when both major parties are cooperating in crime and can override the wishes of the voters at their whim? The consensus amongst the politicians and their enforcers is clearly that they have contempt for the population and the voters, most of who they correctly surmise are woefully ignorant both of their rights and the law. The only rational path is to deny them any semblance of compliance or support, tacit or overt. Fortunately, that is also the lawfully correct path, for under Article 61, all legislative acts and statutes, etc., are null and void once the security clause is invoked. A question many people have is, why is that so? Where does it say that these laws are defunct? The answer is in the very last sentence of Article 61, which reads, quote, "And we shall procure nothing from anyone, directly or indirectly, whereby any part of these concessions and liberties might be revoked or diminished. And if any such thing has been procured, let it be void and null, and we shall never use it personally or by another." Unquote. Here the monarch, speaking in the plural, indicating that this statement is binding upon all who succeed to that position, states that nothing shall be procured from anyone, meaning either themselves, Parliament, or their agents, which shall diminish or revoke these protections of our liberties. Here they refer to laws or instruments of legislation which go against or curtail our common law freedoms or rights. And the commitment is that if such things are ever procured, they shall be null and void once the security clause of Article 61 has been invoked, because they are never to be used either personally, meaning by the monarch, or by another, meaning anyone assuming legislative authority, such as Parliament. It's all there in black and white, and all people must do is to sign their oath and notify the imposter agents of the Crown that they no longer have jurisdiction over us, and our freedom is secure. There is absolutely no need to participate in sham or illegitimate elections, or try to scoop out the corruption from within an irredeemably corrupt system. It is said that conformity is doing what everyone else is doing, regardless of principle, while morality is doing what is right, regardless of what everyone else is doing. Just stand down. Thank you.